Good morning, everybody. This is Dennis Blunt. I'm obviously president of the Baton Rouge Bar. This is I guess this meeting, the hosting of this Zoom meeting is testament to I guess the statement, famous off-quoted statement.
Yeah, I want that off.
Well, let me start with this sort of instruction. Everybody that is not a judge or one of the bar presidents should mute their screen and keep it muted. We will. We're going to have questions that we've received already posed to the judges, and we have questions that we might be able to get to that are sent through the private chat. I'm sorry, through the chat function of Zoom. If you get those questions to us in the chat, if there is time remaining at the end of the Zoom conference, we will get to those questions as well. I wanted to thank Judge Fields and the judges of the 19th Judicial District Court. Judge Fields contacted me, I guess that was Wednesday, Judge? Tuesday or Wednesday, and between those times, we've managed to get the Zoom conference together at the request of the court in order to solicit feedback from lawyers on those things that are both working well and those things that are not working so well, such that the court can disseminate information and do some course corrections if lawyers and litigants are having problems having their matters. I'll go ahead and say heard, and I'll say heard in this context. I'll read you this quote. If you can't fly, then run. If you can't run, then walk. If you can't walk, then crawl. But whatever you do, you have to keep moving forward. That is a quote of Martin Luther King, and I think that is what the court aims to do. And I think it is what the country and our state and all of us as practitioners serving folks need to try to do. If we can't run, we got to keep moving forward in whatever way we can. Thank you, Judge Fields. I'm going to introduce, I think I'll allow Judge Fields to take the mic at this point and sort of introduce the court and talk about any other format issues that we have.
All right. Thank you, Mr. President, and also thank the other presidents that are joining us, Mr. Michael Victoria from Louis A. Martinet Society, Ms. Jan Reeves from Broward, and Ms. Mary Roper from Ends of Court. So thank you all for giving us this forum. Judges that are participating is Judge Kelly, Judge Capacci, Judge Marabella, Judge White. Judge Jackson was on, but we had a little technical difficulty. We're trying to get her back on. Judge Morvant is trying to get back on, and Judge Anderson is trying to get back on as well. So, like I said, I want to thank the presidents for allowing us to come before you all to discuss what we're doing at the 19 JDC to try to keep the wheels of justice turning. And we look forward to taking your questions. The format would be each bar president would ask us a question, and I will direct the question. I will either answer the question or direct it to one of my colleagues for them to answer. And if any one of my colleagues have any other comments that they would like to make after one of us speak, then they will finish the question. So we look forward to answering y'all questions to try to get the 19 JDC standing back up in this public health crisis.
Thank you, Judge. I neglected to mention that in addition to the chat feature, there is a raise your hand feature, and that is something that we hope to be able to get to at the end, such that we'll be able to hear from members of the bar directly if they have follow-ups to any existing questions. That's how I'd like to sort of use that raise your hand feature, if that is fine with the court.
I'm sorry, I failed to mention that we got our judicial administrator, Ms. Ann McCory, here with us as well to answer any questions that you all may have from a judicial administrator standpoint. And want to thank Ms. Ann Scar also for putting this meeting together, and Landon Hester. Thank you.
One other note, and we're going to jump right into the questions, and that is for those who we seem to be having a capacity issue, and we actually had expanded the bar's Zoom capacity beyond what we thought we would have for this. Somehow that didn't come online as of yet. Likely it will, hopefully it will during the course of our meeting. If not, you know, all is not lost. We will still move forward because we are recording this, and we'll push it out to everybody on the bar's website and on all of the bar's social media pages. And I would venture a guess both Brawa and Martinet will provide links to the recording as well. Before I launch into the first question, just quickly, Jan, Mary, Michael, if I've left anything out, please let me know.
You're doing a good job.
Yes.
Oh, no, move along.
First question. If we submit by fax filing or email filing a petition and pleadings to file, will we, this is in connection with a will, petitions or pleadings filing a will and have an executor appointed, can we still get an order to execute the will and letters of administration just with a copy of the will? Can we put the petition in the petition that we have the original will that will be filed, you know, directly with the court later when the court opens up? And I think this question appeared multiple times, and the real gravamen of the question is, and it covers a multitude of things, what about those instances where you have to have an original document that is filed in order for the court to take some action? And I think the second question that I saw with regard to this is folks not wanting to trust at this point original documents with the U.S. Postal Service. They don't even want to mail it into the court.
I'll start off addressing that question, then if any one of my colleagues want to join in. That's one thing that we've been talking to our duty court office in reference to handling the wills and working with the court's office in terms of doing so. And right, as it stands right now, we're going to continue to process all of that comes in and try to work through that issue in terms of not having your original will. But that's more of an issue that we got to try to get a little bit more clarity with the clerk's office in terms of what else can they open up so individuals can bring in those original documents to file. At least that's the information that we've kind of received at this point. If any one of my colleagues want to join in on that.
I think that it's a very difficult situation. We're not only talking about wills, but we're talking about original notes and things like that for matters, but we have the ability, and I have been processing and signing orders for those matters that have already submitted the originals. The lack of the originals is problematic on a judgment of possession for sure. That's the most critical part of it. I think if we have the affidavit stating that someone attesting that they do have the original will let us get through until the judgment of possession. But a judgment of possession because of transfers title is very problematic to me without having an original. How do we get around that? Good question. You know, there is a provision in the code for a lost will affidavit. I would assume that this is almost akin to that. We might be able to use that procedure. I'm not sure. Maybe somebody can, I don't know when it would ever come up before to research, but treat it as though it's a lost will and be able to get a lost will affidavit and then supplement with the original as a found document. That's my only thought.
Any other judge want to respond? And to finish up what Judge Kelly said, Mr. President, what we would do is see how we can work through that issue with the clerk's office, then give you a more direct answer in terms of having the originals. Because one thing Judge Kelly just said in terms of an affidavit stating that you have the original may be a way we can get around attorneys not having to send it in through the mail. But we'll give you a direct answer so you can put out to your membership.
This is a good point to note that part of the reason that Chief Judge Fields requested this was to see those issues that are coming up that we need to figure out, not only answer the questions, but figure out a way to address. And this is obviously one of them where original documents need to be filed. If I could.
Now,
Judge.
Judge, one thing I was going to say, we do allow, there's emergency filing from 8 a.m. to 12 o'clock noon with the clerk of court to walk documents in for emergency filings. This may fall within that. I don't know. Chief, what do you think?
All right, I'll work with the clerk's office and see about original documents, and especially on the will side, to see if we can extend that over at the airline branch in terms of emergency documents being able to be filed, and also at the 19th.
Jan?
Yes, you want me to ask the next question, Dennis?
Yes.
I think it was almost already answered by Judge Fields, but someone from the bar was concerned about whether they can bring any civil pleadings in to be filed electronically instead of just emergency motions, and if it could be expanded to any civil pleadings. Would those civil pleadings received during the time of the shutdown, could they be set for hearing, and would the service go out?
The answer to, you can file anything that you would normally file right now, either by fax, either e-filing, or through the mail. So anything that you file right now is going to go to civil processing. They're going to process into each division and act accordingly. As it relates to hearing, that's a little bit more tricky under the stay-at-home order in terms of having hearing. But any filings, you can do that right now. Any colleague want to join in on that one?
The way we've been treating it in my division so far is, as we receive those documents, Paula has been setting dates far out, like August-ish, for hearing dates, so that hopefully this matter will be over by then. And we've been leaving open the period from early September, late August back to now to fill in those that were disrupted. So at least in Division 22, I think you're going to get a hearing date. It'll just be a little later than you would hope for.
I'm sorry. And was that, and Gregor, was that for me?
And you're muted.
I believe Judge Morvant has a comment.
All right. This is what I'm going to do. I don't know if this will work, Landon, but I'm going to call Judge Morvant from my cell phone so he can.
Cell phone.
I'm sorry.
Judge, he's actually on my cell phone right next to the computer.
Oh, okay. Okay, well, go ahead. Answer. Let Judge Morvant go.
Listening in, and anybody wants to file, the only thing you can't do is walk it in. That's limited right to emergency filings. And anything that's going to be processed, matters, successions, any of that stuff, that's being processed and sent to the various divisions to handle. As Judge Kelly said, the tricky part is setting something for a hearing, because first of all, the Supreme Court is the one that suspended all hearings except for emergency. And your regular rule days and stuff don't constitute an emergency. But the bigger hiccup is we don't know when this ban is going to be lifted. So, if we set stuff in July, yeah, we may have a hearing in July. It may get pushed back to August and September. We don't know. That's the big unknown that we're dealing with.
Next question, Mr. President or Madam President.
Michael, you're up.
Your mute's on, Mike.
Can you all hear me now?
Yes.
The next question is whether or not or how judgments that have been already submitted to the court can be signed and notice mailed. How is the court handling judgments that have already been submitted to the court?
The way that if a judgment has already been submitted to the court, each one of us now have civil processing is sending that information to our individual courts, and each one of our JAs are working their civil filing just as if they were in the office and sending it to each one of the judges. We all now have equipped ourselves with laptops so we can log into the system at home. We're signing judgments and we're sending those back to civil processing for them to complete their processing and send everything out to you. So the way the court is trying to operate right now is remotely. So anything that we were doing in our office, we're doing it now at home. So feel free to file your documents. The clerk office is going to process them, and we're going to look at them just as if we're in the office. The only thing we're limited on is having hearings, and hearings being of emergency nature. But if it's not an emergency hearing, we're still processing everything the same way as of now. Any other judge want to comment on that?
With the exception of, this is Judge White, with the exception of, I'm processing any requests for contradictory hearings, meaning I'm signing them, but until we get a better sense, I have not said any. But as a result of the input from the bar today, then maybe I can get a better sense of what my colleagues are doing and what I should be doing. But so far, I'm signing everything that comes through, processing it, and forwarding it to my judicial assistant for processing, but she has no instructions at this time as to when to set any hearings for any contradictory hearings.
All right. And I see we have Judge Anderson and Judge Jackson. They have worked through that technical difficulty to get them back on. All right.
And Judge, I think Judge Landon might need to take a look at Judge White. I don't think I have her video.
Right.
Okay, I can't see anything. I can just hear.
All right. Well, let's leave it like that for right now until we can work through, so at least she can hear and we can hear her.
I have been informed that the issue of our capacity has been resolved. So some additional folks, if you're within earshot, you have capacity to join.
Okay.
Okay, so I can go off and then come back on then, you think?
I wouldn't do that, Judge White. I'll just stay where you are.
Okay.
Mary Roper.
Yes. The next question is that garnishment judgments have been submitted but not signed. There's some question about what can be done to get these signed and served.
I'll let Kelly or Judge Morvan answer, or I'll take it.
No, I'd be happy to take that. Throughout all of this, we ask for your patience. The ability for the judges to sign documents only got implemented, I think Wednesday was the first day that we finally got the technology available for all of us to work from the house and get our JAs or law clerks in processing and getting them to us for signature. We are now signing all of those on a daily basis and sending them back to the clerk of court. But I know you wouldn't have seen the fruits of that yet because we only had the ability to doing that Wednesday of this week. So from now on, we're set.
All right, next question.
How is the court? Let's see. I think we covered that one. I think that was another succession question. Does Governor John Bel Edwards 3/16/20 proclamation suspending legal deadlines affect when a litigant needs to file a notice of intent to seek a writ on a decision that was rendered by a trial court before the proclamation went into effect on March 16th. Specifically, does the proclamation's suspension give each party more time to file a notice of intent to seek a writ?
All right. I'll take it. Judge Morvan is still on the phone?
He was joining
Okay.
the meeting. He's no longer on my phone.
All right.
I don't mind responding to it, Judge. I don't mind responding.
All right.
The order from the Supreme Court suspends all timing so that once it's put back on and the suspension's done, you have whatever time you had left to do it. It's not going to give you an additional, it's my understanding from talking to the court, it's not going to give you an additional period, but that you do have what you had left. So you're not going to be punished for not getting it in on a judgment that was signed prior to the implementation of the delay. I also have talked to them. Everyone, I think, appellate courts, at least the First Circuit and the Supreme Court, are going to treat this fairly liberally as far as making sure that we don't cut off anybody's rights with regard to the when the clock starts again. Does that answer that question, I hope?
I think it does. And I think the last thing that you said was really critical. And as a approaching old lawyer, I remember everything after Katrina was, you know, if you had a legitimate Katrina issue, you had a whole lot of leeway. But there was at least a smell test on the legitimacy. But if you said you made an effort and you couldn't or were impeded in some way, I think all of the courts in the state were cognizant of something that was impacting all of us. And that likely will be the outcome of this, I would pray.
I suspect so, yes. Yes, I suspect so. Now, don't take advantage of it, though, because we're not talking about a situation where people can't get into their offices or can't have access to type or file, because you are allowed to file and everything now. It's not like places are flooded or anything and machines destroyed. Keep in mind that the court is going to be looking at it that way.
And here's another thing that, you know, in talking to folks, and as it relates to the governor first order in terms of April the 13th, now it's April the 30th. If you had a deadline that fell due in, say, April the 12th, some school of thought is that now your deadline is April the 30th or May 1st in terms of when you have to have your stuff in, because the deadlines are suspended until April the 30th. So meaning the very next day, your stuff may have to be due back in. But if you had, 7 days to perfect your fax filing, then it may be 7 days after April. All right.
Excellent point, Judge. And that was actually, I think, at least 3 of the questions that I read were along those lines. Jan?
Yes, the next question was on fax filing, asking because of the closure about the 7-day rule that Judge Fields just answered that question. But an additional question that was being asked was, do they go ahead and estimate the cost of fax filing, or can that wait until May 1st? Because there's no one in the clerk's office to send out the notices as to the cost of the fax filing.
Well, and I'll take that question, because we just dealt with that with the clerk's office as it relates to how much it costs to, once you fax file, to get that estimate. They now have someone in the clerk's office. If you call them, they will give you that information just as if they were back open. So you can get that information. I heard there were some attorneys who was fax filing but wanted to know how much it was going to cost because they had a bunch of exhibits. Spoke with Elisa in the clerk's office. They're saying that they can do that now. So you should be able to get your cost. Question?
Well, I guess you've covered another question, and that was actually someone had a request, which was, could you end up with a situation where, just given the circumstance, some filing expenses or costs would be waived for some interim period. I will let y'all, I throw that out there for future consideration, given the financial pinch that likely will befall everybody during and after this. I'll leave it to the judges. But that was one of the questions. Next up, Mr. Victorian.
This question, I think, is similar to others that has been asked, but it's specifically, I think, to summary judgment hearings. Once the order that's currently in place is lifted, it will impact hearings scheduled in the days and weeks that follow the lifting of the suspension. For example, if a hearing on a motion for summary judgment is set for early May, a timely opposition to the motion under Article 966 would technically be timely filed in April, only a few days after the hearing on the motion, or excuse me, a few days before the hearing on the motion, in connection with hearings scheduled shortly after April 30th, if and when the order is lifted. How does the court intend to address the issue of timely filing briefs and other such matters prior to a hearing that would be set shortly after the order is lifted?
I can tell you what Division 22 is not going to set anything for at least 15 days after the end of it, so that an opposition will be timely filed. Anything that's previously been set for those dates, we're going to move all those dates. Okay, so I'm not going to have any hearings on summary judgments on, say, the 7th of May or anything like that. Anything that's already set is going to be moved in Section 22, Division 22, to allow for at least 15 clear days position to be filed during this, when it would have been due during the suspension. I think it might just be a divisional matter. I don't know. Wilson, what do you guys want to do?
My thing is, right now, I'm setting stuff for June 1st, with the understanding that June 1st may even have to be moved. So we come out of this on April the 30th. So we got the whole month of May, and then my first rule day is going to be June 1st. However, that may have to be pushed back to June, July or August.
Yeah, to the extent that the question had to do with matters that were previously set for hearing in May, you already have a hearing date. We are moving all of those dates and setting new dates. Okay, so that is not going to be your hearing date, and that's my understanding. I think the other civil judges agree with that. Is that correct, Wilson?
Yes.
Yeah.
All right. And Mr. President, before we go on to the next question, we'll take the next question, but I got Judge Kerfassi, Judge Anderson, Judge Jackson, and Judge Marabella here. And if there are any questions on the criminal side, we want to take those questions as well. And if we'll take whatever next question you have up, and then if you can look through your questions to make sure we can get some questions on the criminal side as well.
With that said, Michael, could you jump to the, it'll be Mary up next, but if you could jump to one of the criminal questions to make certain that we get to the criminal questions early, that'd be good.
Yeah, sure.
I think we'll go to Mary next with a question, but I was going to try to also jump to one of the case management schedule questions, and there were numerous questions about the case management schedule, so I was going to get to that on the civil side too, Judge.
Okay.
Mary?
Okay. Do the judges anticipate holding extra rule days upon the court reopening to accommodate the filings being done now and until then? And also, is there any expectation or plan to have video conference rule days to assist with discovery and evidence issues?
I'll start off, Judge Kelly. We have not discussed as a court in terms of having additional rule days. Now, individual section may try to do some things to catch up on his or her docket, but as a court, we have not discussed additional rule days. As it relates to video conferencing, we have discussed that to try to see how we can do some video conferencing. They're already doing it on the criminal side. On the civil side, we're trying to get our courtrooms equipped where we can do video conferencing if need be, if this public health crisis continue beyond April the 30th. Judge Kelly, you had anything you want to add?
No, I think you got it. Thank you, Wilson.
All right.
I have something I'd like to add, Judge Fields.
Yes, ma'am.
In section 27, and of course it is the bar originating it, we've had several status conferences by Zoom, but it's because of issues like we just discussed, you know, timelines and trial dates are coming up closely. Folks are having experts flown in, and the attorneys wanted to have a consensus as to whether we were going to go forward with a trial, what it's looking like. And so in my section, we have been Zooming, resolving some of those issues, but it's not at the court's request right now. It's when the attorneys feel that they need to talk with us. So in section 27, I'm very accessible, and we can work out a mechanism to Zoom, you know, to take care of those issues.
Judge Fields, you want to go ahead and sort of announce that sort of proactive change that y'all were putting in place with regard to calling into the court and trying to get conferences, et cetera?
Sure, Mr. President, since you put me on the spot.
Well, it worked well with what Judge White had just said.
All right. But here's what we're doing, and Judge Kelly spoke to it earlier about us trying to make sure we get our offices remotely. Right now, hopefully starting next week, you'll be able to call our regular office line, and it's going to be transferred to our judicial assistants or whomever we designate in our office, so they can take your calls just like they're in the office, because we all have technology now, so we can work from home. So anything that happened in the office, we're going to be able to do home. And in terms of holding status conferences, we're going to be able to hold those status conferences like Judge White is doing through Zoom. Some of us may do it through, just do it telephonically, but we're going to be back hopefully up and running the mid part of next week. We can get all our phone lines synced with the court. So hopefully we'll be back in line.
I need to make another reminder of, for all that are not sort of speaking or on the panel of judges responding to questions, if you could mute your device. This is I guess the last question along these lines. We'll try to get to make certain we get to some case management questions. And after we do some of the criminal questions, well, but I guess this question is, lawyers are lawyers, I guess, and this speaks to something I think that is going on with several folks. Can we force depositions of witnesses? If so, how should we proceed? Video conferencing? Does the court reporter need to be present with the witness? Can the witness insist that his or her counsel be present? Can we insist on being present? This is there were a couple of questions that fell into I'll call it the space of folks just not getting along too well. It doesn't sound.
Well,
how are folks supposed to generally proceed with depositions and other discovery?
to the extent that you can, certainly we ask that you continue to move your cases forward. And if you need some help from the court in terms of a status conference, we're here to do that for you. But as you all know, with the order from the governor in terms of all deadlines are suspended, we're going to try to do all we can to help you move your case along. But to the extent of forcing someone to do something, I don't think any of us on the court side can do that. Judge White or Judge Kelly, and if Judge Morgan is still on.
Yeah, I think that Wilson is correct. If there's an extension of deadlines, remember a case management schedule contains deadlines. They're all extended. Notices for depositions constitute a deadline to show up for something. They're extended. We can't force you to your deposition. And we certainly can't force someone to be deposed if they're represented by counsel when counsel can't be there. So we are certainly not going to be involved in that part during the suspension of activities. Guys, keep in mind, if at any time during our history we've needed to be implementing professionalism, now is the time. And so work together. Get mad at each other after this is all over and go back to antics after this is all over. Now is the time to work together. And believe me, the court will not look very kindly on someone who's trying to take advantage of this type of situation going on. That's all I'm going to say.
All right. Mr. President and Madam President, if we can now at least take a couple questions on the criminal side.
Maybe with that said, Michael, can you jump in?
Sure, I'll jump in. We have a question of how will the court handle motions for speedy trial?
I'll let one of the judges on the criminal side answer that.
When you refer to motions for speedy trial, are you talking about 701 motions, or are you talking about a motion that an attorney has filed after arraignment seeking a speedy trial?
I think the question is to both, Judge Jackson, to both issues.
Well, as far as the 701 is concerned, the law says that you're not entitled to an automatic release if you're not bailed within a certain amount of time. If there's good cause that you're not bailed, then they'll be dealt with in the same fashion as they would if this wasn't going on. As far as motions for speedy trial, obviously, if we're not in session, we can't set a trial for a time where we're not allowed to have court. So I don't know specifically what the question is addressing. I mean, we'll be doing arraignments as the district attorney files bills of information. We're going to be doing arraignments remotely. Nothing that is happening will prevent the DA from filing their felony bills within 60 days and their misdemeanor bills within 45 days. And as those are filed, we'll be doing the arraignments remotely.
And I'm sorry to interrupt. I know that I'm not criminal bench, but if you look at the Supreme Court's order, it specifically addresses 701 and speedy trial issues in it. So I don't know why there's a question.
Gotcha. Mary, do you have a criminal question?
Why Mary?
I'm sorry.
Let me do this. Judge Kafasi, won't you give the bar a brief overview of what the judges are doing right now to handle those individuals who are incarcerated and what the duty, and then maybe Judge Anderson or Judge Marabella can tell them about what the duty judges are doing right now while we're in this public health crisis.
Happy to. Thank you, Judge Fields. Basically, and what Judge Kelly referred to earlier about lawyers being professional and getting along and working with each other, that certainly applies to the criminal bench. The DA's office and the public defender's office have worked together very well in an effort to address as many cases as possible for those who are incarcerated and get their cases brought to the attention of the court. And in some cases, reconsiderations for bond have been granted. In other cases, resolutions have been reached that result in persons being released. And we do have the availability of court call to have those hearings or appearances conducted remotely. And the judge that's on duty each week is handling those along with the regular call out process. Judge Ron Johnson's on duty this week and has been very active in addressing several matters. So all of those are continuing. My message to the bar is that, if you represent someone who's incarcerated, the key would be to contact the chief district attorney in that section and see if there's a possibility of having your case brought into court remotely. Any plea agreements that are proposed or sent to the judge that's in that section for approval first, and if approved, it goes to the duty judge for execution. So, you wanted another judge to address the duty?
Yeah, if we could.
Okay.
What is? Yeah, I think one of the questions is need clarification on the. I guess what is criminal duty doing now?
I'll defer to one of my more senior colleagues.
Well, I'm about as senior as you can get, so can you hear me? All right. What we basically are doing is the judge who is on duty, and of course, criminal lawyers know we go on duty today at noon till next Friday at noon. Judge Higginbotham goes on duty at noon today. And basically what we are doing is we are doing call out every day. Those persons who are arrested and are not immediately bonded out, we see them first thing in the morning and set their bonds and let them know what their bonds are. Now, of course, because of the Supreme Court directives, we have been much more lenient in setting our bonds, much more lenient in allowing people sign outs, depending on the type of crime, obviously. The judge, in addition to handling their call out, will also handle pleas or any other disposition that can be done over video conferencing during their section. And the way Fred explained it is that what's happening is the DAs and the public defenders, primarily public defenders now, but if there are private lawyers, they need to be contacting the DAs. I have not had any private lawyers contact me about dispositions. I have had private lawyers contact me about bond settings and trying to have people released. But the dispositions need to be contact the section of the DA's office in your section. And if y'all can reach an agreement, then that is then relayed to the judge who sits in the section where you're trying to get a deal, so to speak. And if that judge agrees to it, and most of us are agreeing to anything that's sort of reasonable. We may not have agreed to some things that we're agreeing to now in normal times, but we're doing it a little more. I think we're being a little more, many defense lawyers would say, more reasonable than we've been in the past. We are really trying to resolve as many cases as we can. And I will tell those lawyers who are on board, who probably know me, during these unusual times, it's going to be rare that I turn down something that the DA and the defense lawyers agree on. That's not ordinarily normal, but that's the way I will do that. So Judge Higginbotham will be taking pleas from anyone who has made an agreement and they can resolve the case. Now, it has to be done in advance. You can't do it tomorrow morning. It's got to be at least a day in advance to make sure that the judge that's handling the case, whose case it is. For example, I'm Section 8. If you have someone in Section 8 that you want to try to resolve, he's in jail on a burglary and he's been there for 6 months, and the DA agrees to allow him to plead guilty and get probation, that is to be relayed to me. I will agree to that, and then Judge Higginbotham at his next court date would take that plea. We're set up to where they're brought in from at the jail. They are video, audio transmitted to the courtroom. We're using Judge Crafasi's court. He's the one that's set up for all of this, and we take the pleas. We're not doing everything. We're obviously not having motions or hearings of any kind where there's witnesses or evidence, but we are trying to dispose of cases. Probation revocation hearings, we're trying to release people who have probation holds on them if they're not dangerous to be released. Those are the kind of things that might be agreed upon between the DA and the public defender or the defense lawyers. I think that kind of covers it. I don't know if anyone has any other questions about what the duty judge in criminal is doing.
I see a related question on the chat,
Okay.
Mr. Burkhart, and he's asking if the inmate at Parish Prison can be set up with a video conference with the attorney. I'm aware that the Parish Prison has set up phone conferencing. I don't know that it's video conferencing, but check with the warden's office. It's my understanding they have accommodated lawyers with telephone calls to their clients to discuss matters before appearing in court on the audio video setups. So,
And Judge, in follow up to that, Franz has a second question. I've seen two questions I'll collapse. One is from an attorney with a May 11th civil jury trial asking, can they assume that'll be reset? And then Mr. Burkhart asking, given all these civil jury trials have to be reset, will the criminal cases based on speedy trial issues be given priority over those civil trials?
I'll defer.
We have separate civil and criminal divisions. So the deferrals of civil juries have effect on the criminal juries. They have their own dockets. Normally on most of the other districts, criminal takes priority over civil, so your civil jury trial get bumped if there's a criminal trial going. We don't have that situation in the 19th JDC because we have separate civil and criminal dockets. So that's half the answer. The other half the answer is I don't know who you have your May 11th jury trial with, but I suspect that it was probably going to be rescheduled. But just all parties can all be properly prepared for it. But it's up to, right now it's a divisional matter after the close of the delay that we have. Wilson?
I can tell you in Division D, Section 25, we more than likely not going to have any jury trials in the month of May. And here's the reason why. Because if we come out of it on April the 30th, the public, I think, is still going to be in this mode of staying away from each other. And when you try to bring 200-300 people down to jury management, that's going to get a little tricky. And folks sitting right next to each other in a jury box is going to get a little tricky as well. So I know for the Section 25, any jury trials for the month of May, we more than likely not going to have them.
It's the same with 22.
Same as 27.
Dennis, I have a couple of criminal questions if you'd like me to pose those.
Yes.
Okay. First one is, as far as putting people on probation, is there any consideration to an alternative of community service requirement whereby they could perform community service not out in the community? And then the second thing is regarding parole board. hearings. If you have any knowledge based upon whether or not the parole board is currently holding preliminary and parole revocation hearings that are subject to appeal by the 19th JDC, and if so, what witnesses or information would be helpful or necessary to the court to expedite the process if there is going to be a habeas corpus writ filed.
One of the judges on the criminal side.
All right, Judge Fields, I'll answer that. We don't have anything to do with the parole board hearings. We're not even aware of most of those when they go on. We do have to make a comment whether or not we're in favor of it or against it. But as far as the community service, most of the probation is for a period of at least a year, and they should have plenty of time to do it. But I'm sure I will, and I'm sure every other judge will take into consideration the inability to do community service because of the governor's order.
Let me, this is a question that dovetails your earlier comment, Judge Fields, with regard to jury trials in the month of May. Is there any similar concern with regard to holding hearings in the month of May? Just likely we will sort of be staged back into having mass gatherings.
If the governor does not extend the stay-at-home order past April the 30th, then I think each court is going to do what that court deemed is appropriate under the crisis that we still all may feel that we're in. I may have some hearings, but I'm still probably going to try to limit the number of folks in the courtroom during those hearings, unless we get something, from higher up saying, okay, the line has flattened or the virus is gone. I think everybody still should be very cautious in terms of keeping their distance from folks. But if the stay is lifted on April the 30th, then come May, I'm going to try to start conducting court as best as I can with whatever matters I may have on my docket in May, but I still may not have a courtroom full of people on Monday mornings for hearings. If it's a hearing that's not affecting a trial date that's coming up in June, July, or August, then 9 times out of 10, we're going to look to see how we can reschedule those matters to keep the number of folks down in court, at least in Section 25. Judge Kelly, Judge White?
No, I agree. I think I'd already stated, at least with regard to summary judgments in the month of May, I'm not going to be setting any hearings on a summary probably in the month of May. Also, with regard to any other matters, while normally the rules are on Monday, I'm going to probably try and accommodate the need to have hearings based upon requests from counsel during May and not just necessarily on Mondays. I'll probably try and stagger them throughout the week so that we don't have too many people in one place at one time.
Judge Morvant?
Yes, can you hear me?
Yes, we can hear you.
All right. I don't anticipate, assuming for the sake of argument that April 30th, the order is not extended, I'm thinking the first probably 3 weeks of May, I'm going to have limited hearings just because of the inability of counsel to comply with the rules of getting in their oppositions and their replies. And then I'm going to start setting them from them. Sort of like Judge Kelly, if we're not going to have a lot of jury trials during that period of time, we don't have to have just Monday morning rule days. We can extend it to the afternoons. We can do it during the week to try to get as many matters set and heard in late May, early June as we can. But Wilson, I sort of agree with you. It's going to depend upon what each case looks like. If all the briefs are in and they're ready to go and they want to have their hearing, by all means, I'll hear it. if counsel's been hampered and not able to get something in, I'm going to take that into consideration.
With respect to Section 27, this is Judge White. I don't have a permanent court reporter. It was my intention to stagger rule days when we come back, not have any on Mondays, because I was expecting that my colleagues their court reporters would be tied up on Mondays. So I'm going to have to meet and powwow with my colleagues so that we can coordinate, at least I can coordinate having a court reporter. And so right now I can't say how I'm going to do it, but certainly this squeaky wheel gets the oil. And so I'm encouraging counsel to contact our office and we will accommodate you.
Judge Fields, if I may ask a question for the criminal, on the criminal side, there's a question of how the attorneys can get any guidance on how to clear bench warrants.
I'll be happy to take that. If you know which section issued the bench warrant, just contact that section. We're looking at those, we're reviewing those, and in light of the circumstances, oftentimes lifting those, unless they're based upon the, committing a new serious violent offense, then that may remain in place. I guess just the thing to do is to contact that section in any way, either through the DA's office or through the public defender's office or through our office directly. We are currently in the process, just effective yesterday, of getting cell phones for each judicial assistant, and the phone lines from the office will be directed to these cell phone numbers so that our sections can be contacted and messages can be brought to our attention. In the meantime, we're all, I think, checking our emails. So that's a good way to get in touch with us. Hopefully that answers the question. If anybody else has something to add.
Well, if you're talking about people who've been arrested on bench warrants, I've been advised that the sheriff, or they're not arresting people simply on bench warrants. It's if you get arrested on a new charge and then you have a bench warrant attached. Now, if you're talking about a person who hasn't been arrested on a bench warrant, I don't anticipate recalling that bench warrant because there's no way for the attorney to sign notice for the client or for the client to sign notice for themselves. And so generally the issue has come up with people who've been arrested on bench warrants. They've gotten another charge. They can make bond on that new charge, and they're asking that their bench warrant be recalled. We can do that because we can have that person sign notice at the jail for their next court date. But if they're just out there and the bench warrant is outstanding, I don't anticipate those bench warrants being recalled until the situation with shutdown is resolved.
Let me, I want to sort of pile three things all into both civil and criminal, all sort of condense it all into one series of questions. On either civil or criminal, and you have lawyers on both sides with somewhat of an agreement, how do you get notions of that agreement before the court as to how to proceed in an instance? And before you respond, think of it in terms of both criminal and civil bench. I think the criminal side has pretty much been answered by Judge Marabella. But if there are there are similar pleadings on, if there's something by pleading that either criminal or civil that the parties would like to just submit it on briefs without argument, is the court moving forward with any effort to consider those matters if the parties have stipulated that they don't need to see the court, and with the court review those pleadings and rule on the pleadings, either in civil or criminal.
From the civil standpoint, you had two questions in there in terms of if y'all have an agreement. I thought maybe you was talking about if you're settling the case. And the other question from the civil side is, will we rule on your pleadings? As Judge Kerfasli just mentioned, hopefully by Wednesday, all our office phones are going to be transferred to our JAs. And if you have a situation where both lawyers got an agreement or both lawyers want to talk to the court, then you call our regular office phone line, and then our JA would do the same thing he or she does as if they were in the office in terms of setting up a phone conference with those attorneys so the judge can discuss that matter with them. As it relates to asking us to rule on the pleadings, we as a group, if I recall, has not discussed that yet, but and maybe that's something we'll discuss to determine whether or not we're going to start ruling on things on the pleadings and doing a minute entry. So that's and you know, maybe what to do, and I'll let Judge Keller, Judge Morvan, or Judge White into that, and maybe we come up with an answer right now.
Well, I'll jump in first. I know that you want rulings on things. Remember, if you submitted briefs that requires written reasons to be drafted by the judge and in order to be sent out. We don't have a way to get an order sent out at this time that's not been submitted to us, okay? We don't have access to our typewriters and machines and everything in the office to generate those. So preferences to not rule on the pleadings. I mean, we wouldn't have to start generating them until later anyway, but I think it needs to be a division by division, instance by instance matter. Some things have to be, it's critical that they get decided. And if you contact the division, I think each judge will weigh each individual circumstance as it comes up. I don't know that the court wants to make a blanket that we will or will not rule on the pleadings. I think it's got to be divisional and circumstantial in this essence.
Judge White or Morvan?
Well, with regards to, and I guess what kept going through my mind, your question, if the lawyers want to submit something on the pleadings, I'm not quite sure how that fits in with the Supreme Court order that we're not supposed to have any kind of hearings except emergency hearings. Once we get past April 30th, Dennis, I know there's going to be people that are still leery about going to court. And if we're back in and we're fully operational, I would strongly encourage lawyers that if you have a summary judgment and you've submitted everything, your brief, the opposition, a reply, and we've got all the exhibits, submit it. There's no reason to come in and have to argue that. And I think we'll be in a better position post April 30th to be doing that than we are right now because of the like Judge Kelly said, the lack of our ability to go in, issue written reasons, have them mailed out and sent out. I mean, we're operating from remote locations. The judges at their residence, the JAs at theirs. But come April 30th, if we're allowed to start having hearings and people would rather submit as opposed to come down on a rule day, then by all means, please do it. Just both parties notify the court that they're submitting it on the briefs.
Jan, you have next question? Or did,
Yeah,
well,
I'm looking at a couple.
I'm sorry, Jen. The one thing I want to add to what Judge Morvan said is please remember summary judgment. The code already stipulates how and what can be used for evidence and when you have to have it in. If you want to submit something on the briefs on any other matter that you want to attach some evidence, make sure that evidence is authenticated and properly admissible. Don't just attach it like you would to a memo to say, remember that we can't take it into evidence unless it is admissible and competent evidence. So that's the only thing I would say with on the briefs.
The request to submit it would obviously have to be accompanied by an agreement of counsel that we agreed that the following exhibits are admissible, because
Right.
We can't on our own say I'm going to interest, and I'm only going to consider it if the piece of the documents we want you to consider, and I'll then consider that as being submitted, and it'll be introduced into evidence. And that way, if it goes up on appeal, a court of appeal can look at it.
And Mr. President, I thought your question was twofold from the civil side and the criminal. Any of the judges that's handling criminal matters want to respond? All right, we'll move to the next question.
Okay, Dennis, you want me to proceed?
Yes, Jan.
Judges, I'm seeing a couple questions on the chat. One is kind of a very general open-ended question as to once court resumes and the elevators are open, if there's going to be any additional precautions taken in the courthouse. And the other question is a very specific criminal question from someone asking on a parole bond, they have the agreement with the ADA to send their client to rehab on a nonviolent offender, but can they do that through a motion and have it be signed electronically by the court, and the same request about bond reductions and electronic signatures?
Well, let me address the, I guess, cleanliness of the court. Before we left, what we were putting in place, that every evening we're going to have the janitorial staff go in everybody's courtroom, go on the elevators, the escalators, and disinfect everything. So each day, the janitorial staff is going to disinfect the courthouse, in addition to what they normally do anyway. So we're very aware that we want to make sure that we, don't not clean the courthouse. So the courthouse will be cleaned regularly throughout the day once we open back up. All right, someone from the on the criminal side.
Okay, the question addressed parole. Again, we have no jurisdiction over parole holds or matters. That's strictly through the parole board. I'm assuming that if you file a motion to lift a probation hold, we could certainly address that through e-filing and e-signatures. Well, I'm assuming the court's office will accept those. But you can always contact our individual offices so that we can pull up that person's case, look at what they're on probation for, look at the reason that there's a hold. Generally, the hold is in place because of pending charges. And so a lot of times lifting the probation hold won't necessarily result in the person being released, depending on what their new charges are. They may not be able to make that bond. But I just think it has to be on an individual case-by-case basis. Once we're set up with the phone system where you can contact someone from our office, that information will be relayed to us, and we'll look at it on a case-by-case basis.
Michael? Michael, you're muted.
Sorry about that. I think many of these have kind of already been addressed, relative to case management orders.
Could I jump in?
There's one that is pretty simple, that I see on here, someone has asked if the court reopens while school and childcare is still out, will attorneys and civil litigants be allowed to bring children to court?
I think we're going, each individual court is going to handle their court in the way that they see fit. A child can come to court and he or she is not being disruptive in court. And if there's, especially on the criminal side, and I'll let them address that, if there's no sensitive matters going on the criminal side, then, speaking for Section 25, if you bring a child into court, as long as that child is not disturbing the court, I'm probably going to be fine with it. Anyone else?
As long as the lawyers don't act like children, I don't have a problem.
And I'm
Yeah,
assuming
I don't.
the children
have a-
cannot sit at the council table.
No.
No.
Unless they have a Louisiana bar number.
I don't have a problem with either, but I echo one thing that the Chief Judge mentioned, and that is that council be aware of the subject matter of the hearing going on in court, because a lot of stuff, especially in the criminal side, that might come out in court is not something you want someone under the age of 37 to hear.
I had asked a question earlier. I didn't see if it was addressed. I was trying to find out whether or not I have criminal statuses coming up, with felonies, and people are supposed to make appearances. This is Jeff Wittenbrink. I had to unmute my audio. I couldn't get my question answered. I have criminal statuses coming up, and we require felony defendants to appear. So how are they handling that? Do we just get new notices to them? Does anybody know the answer to that?
Let me make sure let me make sure the judges understand your question. You have a criminal status conference coming up with one of the sections?
Right. And so what happens is that if you have a felony defendant, they have to sign notice for each time you come. And so
I can explain that. I can tell you what we're doing in our section, and I believe everybody else. What we're doing is going through the docket every day, and if there's a status conference going to fall within this April 30th deadline, we're just reassigning it, trying to send out notice to everybody. No one is coming up to the courthouse. We're not expecting anyone to appear in court to send notices. If your client is in jail, he'll be getting notice at the jail. But we're not expecting anyone to go up currently until April the 30th. Now, what happens after April 30th? No, I think everybody is handling that the same way on the criminal bench. Is anyone, I don't know that there's anything else we could do about that.
That sounds like all that could be done under those circumstances. I'm not as a criminal practitioner, but that sounded wholly reasonable and actually the only option. Can I ball several things up into the same thing? And there were any number of civil questions with regard to scheduling orders, Judge, and I think you have answered a lot, but I think to the extent that there is any question that remains, the notion is suspension. All of the deadlines of a scheduling order, are they suspended? And what happens, I'll go ahead and ask it as they posed it, what happens after the suspension ends? Our courts, does each section intend to reissue scheduling orders for cases because of the changes in things that might have been not only docketed as deadlines, but hearing dates? Or how do the parties come to the court to get new scheduling orders if they need scheduling orders, because some of the dates included like dates for filing things like summary judgment and dates in the scheduling order for hearings on summary judgment? Is that going to be automatic that the court would reissue new scheduling orders, or do the parties need to approach the court to make that happen?
Mr. President, I think the easiest way and the simplest way to address that is that the deadlines in our case management orders, they have been suspended. So to the extent that you have a deadline that's coming up between now and April the 30th, is suspended. And how that affects your case, I think you then should contact that particular judge's office to get a new status conference date so you can get a new case management schedule to put your case back on track. But if your case management schedule gives you dates that extends past April the 30th, once again, I think you need to contact that judge's office to how that particular case management schedule is affected. But what we have discussed as a court is all our case management schedules are suspended as it relates to any particular deadline. Now, how I'm going to handle it in section 25, if you had something that was due in March, then contact my office and you can start doing that, hopefully starting next week, and we'll give you a new status to get your case back on track. Judge Kelly, Judge
Yeah,
White.
but just for clarification, we are not, as a court, I don't think any of us are going to try and figure out from the thousands of cases that we actively have, which ones need a new case management schedule. So it will not be generated by us. You need to actively request a new status. And you can do that. The cheapest way to do it is by, quite frankly. I don't think the code allows you to file it by a motion that costs money. I know in 22, if you send us a letter, we'll get you a status date. But I don't know what the others are doing. I know you also can file a motion, but again, why spend the money if you can send me a letter? But the bottom line is you need to initiate it. And I'm going to.
Dennis?
Yes, Judge.
I agree with what Tim and Wilson said. I don't think any of the sections, civil sections, on their own are going to set new case management schedules. The options that the lawyers have are send in a request for a status conference, or if the parties want to execute a joint case management schedule that sets new dates for themselves up until the pretrial conference, send that in and we'll pick a pretrial conference date, and that's what's going to be in effect. The problem is that this suspension, once it's lifted, civil lawyers are going to still have a lot of trouble getting medical depositions, medical records, because the medical field is going to be on its ear. It's going to be turned upside down. So fact witnesses and other stuff, they're going to pose some problems relocating and finding people, but finding time to take a doctor's deposition, I think it's almost going to be like between Thanksgiving and New Year's, where it's almost impossible to get one. That's going to be something we're going to have to take into consideration. And if the court would set its own deadlines, we can't factor that in. So I guess the simplest thing is ask for a status conference or send in a joint case management schedule signed by all counsel, and we'll approve it.
I think I jumped ahead of Mary Roper.
Judge White, you had anything on that?
No, I agree. Our protocol right now is to email the law clerk, and we will reassign. And but certainly if there's a consensus and you want to prepare another joint case management schedule, then that's fine. And we can operate with that. So I do agree with Judge Kelly that if there's any need for professionalism, it's at this time. And so I would appreciate that and encourage that and respect that to the highest.
Madam President or Mr. President?
Okay, I have one on default confirmations. Is duty court confirming any defaults, and if so, what type of defaults are they confirming? And a subset of that would be if the delay had already run prior to the order going into effect. Is that something that could be signed?
Well, we
The 2-day
discussed-
delay, I'm sorry, after the default, would a confirmation be able to go forward? And if so, would that be able to be done by electronic means?
All right. I'll take it and
I'm glad to jump in and help, Wilson.
As it relates to default judgments, if it came about during the suspension, then we're not confirming because the time that was suspended. But one portion of your question was if the time delay came due to the suspension, if those orders come to us, then yes, because it was before the suspension. But if it's during the suspension, then the delays are suspended. Judge Morvant?
Well, 1002 says you have 15 days to answer. But if you look at that Article 1702 to take a default judgment, you have a time to answer up until the judge signs that default judgment. If the court, if the Supreme Court and the governor's order has suspended all delays, I'm not going to be comfortable signing a default judgment until that order's lifted, because technically, reading 1002 and 1702, they can answer right up until the point that I sign the default judgment. Even if I confirm it in open court, they can still answer until such time as my signature is on the judgment. And if you don't submit it for another 2 weeks, that's two more weeks that they have to answer. So Section 23 is not going to sign any default judgments until after the governor's order ceases to be in effect.
But Judge Morvan makes the same point I was going to make. Thank you, Billy, for explaining it better than I could have, because until the judge signs the judgment itself, it's not effective. Well, if we haven't signed it before the start of the delay period, then I'm sure not going to sign it once it becomes a time period for delay is running, because as Judge Morgan very clearly pointed out, they can answer all the way up until the time I sign that judgment. So once the time delay started, I'm not signing anything for confirmations until it's over and fresh again.
Any other questions?
There's one on the chat about online notarial acts being performed. How are they being handled? Will an online notarial act executed during this time, can it be later rescinded if it was only witnessed via Zoom and not physically present and not an authentic act form? It's a pretty complicated question, but it's on the chat there, Your Honors.
I don't know if that's an advice question or asking us for a ruling on something. So,
That's an advisory opinion.
I
I don't think we're allowed to answer
that's
that.
a question that either one of the judges should answer, because I think that's more of a legal question in terms of how we will rule on something.
I have a question, Judge, as to whether or not when court reopens, whether or not there'll be priority for hearings and trials that were already set for May or June or July, or those that would have to be reset later on, whether any priority will be given.
Well, let me go to someone on the criminal side to answer that, because they're facing more deadlines and than us on a civil side per se. Judge Capacity, Judge Anderson, and Judge Jackson, and Mayor Bella.
I think those people who've been incarcerated during this lengthy period will be given priority. At least they will in Section 1. That's kind of always been the case. And so, yeah, that's the answer.
Judge Anderson?
I agree with what Fred said. We always take that into consideration. And now considering what's going on now, we'll have to do it even more so.
Judge Jackson, is he still here? Judge Marabella,
You're muted.
which is
Go ahead and say it, Wilson. I agree. I agree, of course, with both Judge Anderson and Judge Crafassi. The good news for me is that I probably won't be implementing that, but I think that whoever takes my place will certainly do that. That's the only thing that we can do. We have many people in jail now, but I think all of the judges, all of the criminal judges are working right now to try to resolve those cases that we can resolve with those that are in jail.
Wilson?
move on.
Yeah, for the civil side, what at least for section 23, what I'm doing right now is whatever was scheduled for, say, early March when all this went into effect, we're just pushing everything forward, and that's going to be the first stuff that gets heard. I'm not going to make, if you had something set in March, I'm not going to put you late fall. So yes, the stuff that was pending during the shutdown is going to get priority, and I'm going to try to hear those, both the trials and especially the rules and motions, as quickly as possible.
Kelly?
In Division 22, it's going to be exactly the same. If you had a trial that was set ahead of time and it's been interrupted, you'll be the first in line when I start having trials again, and we'll move other people behind you. And everyone's just going to have to be patient and understand it has to be that way.
Judge White?
That's my plan. However, it's going to wreak havoc in trying to get all of the notices out of things that are being bumped. And so we'll just have to look at it and try to figure out a way to do that is equitable under the circumstances. And I'm not sure that we'll be able to do that well. But we appreciate anybody's cooperation and patience.
And I think what we're saying on the civil side is to trials, just like we mentioned earlier, let us know that you still want to have your trial. So you need to call our office so we can get a status, so we can put you back on the trial docket. We don't want to just give you a trial date and then that trial date doesn't work for both sides. So at least for the trial, let us know. As it relates to rules, we probably going to just start reassigning those rules. But trials are a little bit, in my opinion, a little bit more trickier to make sure that those dates line up with the attorneys, their witnesses, and everybody else. The next question.
Go ahead.
I just have one on discovery, and hope it's not repetitive. As far as answering discovery that's been propounded, I'm presuming that is also extended or suspended. And as far as having a 10.1 conference, are those things that the lawyers should still be engaging in, or is that something that is also under suspension?
Judge Morvan?
Well, I mean, Mary, technically, if you read the order, all deadlines are suspended. I would say that, yes, that probably includes the 30-day period to respond to discovery. The flip side of that is, a lot of lawyers, despite what's going on, are making really good faith efforts to move their cases, have been doing depositions telephonically, have been conducting discovery the best that they can. We're not going to have any motions to compel, despite if you have a 10.1 conference, until we can have hearings. And I can tell you, if I have a 1469 motion to compel, and the other side says, Judge, I was unable to do that because of the governor's order and/or the circumstances I found myself in, I'm not going to grant that motion to compel. I'm not going to set somebody up for 1471 sanctions when despite their best effort, they couldn't do it. But I would like lawyers, again, reiterating what several of the judges said about this is a time for professionalism. Try to work together. The things that you can do, the things you can work on and move, do it. but I think a 10.1 conference isn't going to do a whole hell of a lot of good if you can't file a motion to compel.
Any other judge want to answer that? Landon, I don't know if you can hear me, but I see Judge Smith joined the conference. If you can move him to the front screen so we can make sure.
I've been in the conference. I just didn't know how to unmute my mic and all that stuff, so I did some technological things. So I've been here.
We figured you didn't know what you was doing with that, so that's
Hey,
why.
man. I can't argue with you. But anyway.
All right, so we have Judge Smith with us as well. All right, Mr. President or Madam President, next question. I
think you've kind of covered this, but I'll pose it anyway. And I think it becomes more relevant next week for the court, Your Honors. But the issue is the court still receiving and signing judgments on ex parte motions other than protective orders? And I think that's a live question.
If I understand the question, are we signing? Let me just speak generally. If you file something, it is going to go to the clerk of court civil processing. They're going to process it just as if they were processing before this pandemic, and it's going to be sent to our offices. Our office staff is going to do what they normally do with it and get it to us for our signature. So we are signing things now, and even starting next week, we'll be more up to speed in terms of handling things the normal way that we've handled things. Domestic, I think you mentioned something about a TRO.
Protective orders, and I'm presuming those are the domestic protective orders.
Domestic protective order, that falls within the emergency. So we are handling those matters now. Marvin or White or Kelly, anything different on that?
I think it's going to depend upon the nature of the order. If it's a motion in order to dismiss or something like that, that's a typical ex parte motion. Yes, I'm going to sign it and grant it. If it's an abandonment, say under 561, I think that the 3-year period to take some action has been interrupted and suspended by this. So Dennis, the ordinary course of things, most of those can be signed, especially if they're joint orders. But if it's one that involves a time delay or something that's affected by the governor's order, then I'm not going to sign it.
Yeah, we're going to pretty much sign any joint or consent matter. We're probably not going to sign anything that would otherwise be a contested matter that we'd have to have a hearing on.
White?
I'm signing almost all ex parte motions. I am signing contradictory motions as well, but I'm only signing it, but they're not being set yet. I'm just moving them from my image box to my judicial assistant's image box to plug in the date. But as it comes to me, I signed it, but the dates are not being set.
All right. Jan. Oh, Mary, I'm sorry.
I don't mean to jump in. I'm just.
No, please.
I see a question on the chat about, it says, how can attorneys obtain transcripts necessary for writ applications before May? I'm assuming this is for emergency writ applications.
At least I hadn't thought of that. I don't know what the other judges may say, but if it falls within the category of emergency as it relates to the governor's order, then I would say follow the normal process that you do to get the transcript in terms of contacting our judicial administrator's office, and she will then direct it to the individual court reporter to get that transcript for you. But that's something that we may have to talk about to see what procedures we put in place for that, if it's truly fall within that category of emergency. Someone else has something different. That's all I can think of at this moment.
My thoughts are that this would be a great opportunity for our court reporters to to move the transcripts. And so if a request is made for a transcript, as long as our court reporters have access to the record that needs to be transcribed, I'm sure they would be more than willing to take on that task. So direct that request to the Judicial Administrator's Office, and they will answer or do whatever needs to be done to accomplish the request.
Madam President, one of the difficulties in getting it done is that, yes, they can direct it to our Judicial Administrator's Office and try to but remember, they are not at the office, and a lot of what we need to do is office.
Wilson, I'm sorry to interrupt, but somebody's mic is on. And everything you're saying is being interrupted by somebody's mic, pushing background noise of banging and stuff. Could y'all put your things on mute so that we can hear the judge?
Madam President, the court orders, their stuff is still at the courthouse. And in order for them to do some of those transcripts, they may have to be there to do it. We do not have them set up remotely at home like we have some of our JAs. So to the extent that an emergency transcript is needed, contact the Judicial Administrator's Office, and we'll try to make whatever provisions we can to make sure that it happens if it falls within the order of the governor.
There's one on the chat. If we have a client that would like to give a victim impact statement and a plea is reached, how can the victim provide their statement?
I'll refer that to Jessica Fassy, Mayor Bella, Aaron Smith.
Yeah, I have a sentencing coming up. I don't know how we're going to do that, and I know that there's some victim impact testimony that the state wants to put on. So that's a good question. I don't know when we're going to reschedule that sentencing. So I think if there's victim impact information, that's a major felony, whatnot. And I think it's just going to depend on when each individual division is going to reschedule their sentencing. That's what I would think at this point. Over.
Judge Kerfassi?
I agree with Judge Smith. In likelihood, if you're talking about a felony charge that involves Department of Corrections time, that's going to be rescheduled. Now, the question may be of a concern that these are cases that are being addressed by the DA's office and the Public Defender's Office or Defense Counsel for resolution and for release, because there is an effort to get those who are deemed eligible to get them out of incarceration to help with that population and the spread of the virus. And I take it from the nature of the question, this person wants to be heard in the midst of that process. And to include that in the consideration, my suggestion would be to get with the DA in that section and to make sure that they're aware of the existence of that person in their statement. And that'll be included in the overall assessment of the case.
And Fred, correct me if I'm wrong, if I speak out of school here. If that individual can get with the district attorney's office, the system that you all have worked hard in setting up in criminal court with the court call, that maybe that individual can be piped into the courtroom through court call and still be able to get their victim impact statement in.
Absolutely. That's a very good point, and that would certainly be available to any person that was insistent on being heard. It's done by sending a link via email to that party, and they can be brought into the hearing remotely and appear on screen, both audio and video. And to further, while we're on this, it goes to further answer a question I think Mr. Manasseh has posted. This is set up in my courtroom now. We're working on getting it in all of the criminal courtrooms. And this will be useful going forward. Mr. Manasseh is asking a good question about, in criminal cases, a lot of the general public is invited to be there, required to be there, and there are others that want to be there. And, how are we going to move forward even after the governor's order may expire, but still dealing with the existence of the virus? And to answer that, I think we're going to follow the guidance from our Supreme Court, from the CDC and the governor's office on how to conduct public proceedings. I'm sure they'll be giving us additional guidance. And the remote ability of each courtroom limit the actual presence of parties should also help accommodate that. So.
Mm-hmm. Any other judge on the criminal side? All right, Madam President or Mr. President, next question.
I just have a question. I'm sorry, Dennis, you want to go? This is a question for the court. I think everyone has pretty much heard and understood that May and June civil jury trials may be fairly unlikely with the situation. But what advice can you offer, or what could the court do for persons that are facing down July, August civil jury trials when you have to send your subpoenas out sometimes 6 to 8 weeks early to see if the witnesses can be found and subpoenaed? You have expert costs involved. You have doctors' depositions where they don't want to schedule or they don't want to agree to come to court. Is there going to be anything done to try to set those back to address that generally, or any insight you can give us how to handle pending jury trials that are not immediately after the closure of the April 30th stay-at-home order?
Well, for Section 25, I think the prudent thing to do is to contact my section so we can have a status to see what's the possibility of your trial going forward in July or August, to give you some direction in terms of what you need to do for preparation. But that's the best I can think of at this moment in terms of giving you advice on whether or not your trial is going to go forward in July or August, is to contact my office, and then we'll look at our docket and see what other trials we flipped over to try to manage the docket.
I think that that's very good advice. I think most of the judges will probably be doing similar things. If you're going to have a problem and you're concerned about the timing of things, contact the divisional judge's office, get a status, and we'll work out. Now remember that if you have a case that's set in August or September, there are others that have missed their trial dates that may get you bumped anyway. But it's going to be on a divisional basis or a sectional basis that we have to do this, because we each have different dockets as to when things are set and when there's going to be an opening. So it's hard to say other than contact the judge, get a status conference, talk through the reality of being able to go forward with the judge.
Well, guys, this is Judge White. I'm very concerned about the safety of the litigants, the parties, the court staff. And will things really be different in terms of we may not have we may not be shut in. Well, we may be still shut in. But what about the 6 feet away? How are we going to, and that's what I'm unsure of. How are we going to have 14 people in a jury box, 12 maybe plus 2 alternates, sitting side by side? I mean, how are we going to do that?
Judge White, I don't know the answer to that question either. I think that's something we're just going to have to deal with. This is a situation we have to rely on the authorities that the virus is gone, or if you go get shot, or whatever the case may be, because I share that concern with you as well. On the criminal side, we have to have jury trials. I'm supposed to be in one right now. So when we start this back up, who's to say that some jurors are going to say, well, I'm not going to come to court because I don't want to catch coronavirus? That is a question that we just have to face as it comes up, in my opinion.
All right. Well,
And the reality is that, as I appreciated the criminals jury trials, because the person's life and liberty is at stake.
Judge White and Judge White, let us do that in our weekly judges call in terms of how we deal with some things logistically at the court when we open back up.
Well, I agree too. So we're going to meet, and then that will be communicated to the bar as soon as they.
Right.
Wilson, can I add one thing?
Yes, sir.
Jan, if assuming court is going to be open in July and August, and really depending upon the nature of the trial, if it's a little 2-day jury trial on a traffic accident, we may be able to go forward. If it's a 5-day jury trial with a lot of medical testimony and experts, and y'all have not been able to do the preparation you need, get with the other side. And if y'all want to file a joint motion to continue to give you time so that you have a set trial date, we'll entertain that. That again, that's gonna depend probably more on the cooperation of the two lawyers than it is the court.
And I think that will be at issue. Hopefully most attorneys will be responsive. There is another similar question, Your Honors, and on the chat, someone is asking, how will the court handle jury bond and cash deposits for trials that are scheduled to begin within the next 60 days? So that's jury bond and cash deposits. Most usually are due like 30 or 60 days before trial. Is the court open to handle that? People are wondering if they need to get their jury bond and their cash deposits posted.
Once again, and someone correct me if I'm wrong, but all that falls within time delays, and they're suspended. Now, once we come out of this, if you still have a trial, I think that's something that you can talk with that particular judge, and whether or not that particular judge is going to say, okay, you can post your bond by this date, and we still will have your trial based on his or her calendar. I think that's the only way I can think of right now that I would handle it in my section. Any one of the other judges got something different on it?
The concern is those who have the case management orders that have a date to file the bond that falls within the delay period. And obviously the question is, do we need to find some way to file it or not? During that time period, remember there's a lot of trials ahead of you that have already filed their bond and are waiting to get their trial date. I would suspect it's going to sort itself out. I don't see right now that the filing of the bond is an emergency matter under the contemplation of the order. So we would just talk to your judge to get a new date to file it by. We'll try and accommodate you as best we can. Remember, the code requires a 60-day period prior to the trial to file the bond. I don't know if that's a waivable time frame or not. Billy might know better, but in any event, that's the best we can do to help you with it. We're going to try and accommodate you all, but remember, if you have a trial that is in a time period to file your bond during the delay, there are trials ahead of you that have not been able to go forward that have already filed their bond. So it's going to probably all work out, but we're just going to have to work with it.
Next question.
We have one more from the chat that says that requests or brings notice that the 24th JDC has extended both civil and criminal protective orders, and whether or not there's any contemplation by your honors to do the same thing. Protective orders that would have expired between March 13th and April 30th.
We have already, I think when we first got into this, I was on duty during that time period. So all those, if we're talking about those domestic protective orders, those were extended. And as a matter of fact, we're bringing them back on April the 15th. However, we may have to extend that now. Well, we may not have to extend that because that's one that falls within one of those emergency situations. So we're planning on having those on April the 15th. So a protective order on the domestic side, I think we as judges have all realized that that falls within emergency hearing. So we're going to have those hearings. Is that correct, White, Kelly, and Morvant?
Well, I would say with regard to the expiration of it, if the time period for the expiration falls within the delay period, the suspension period, I don't see a reason to extend them. Quite frankly, they expire of their own term, but technically that period is automatically extended by the orders of the courts already. It would seem to me until the lifting of it. But the more concern is taking care of those people who need the issuance of one rather than one that's getting ready to expire.
I'm sorry, I misunderstood. I was thinking what you just spoke of, Judge Kelly, about the issuing, the ones we've already signed and they're about to expire. So I'm sorry to cut you off, Kelly.
Okay. I know. Now, the question of while the TRO is in place, now the third issue is when there's a TRO that's been issued, and then there's a hearing date during the suspension period. We're going to have those hearings. We have in place the procedure by which to look through them, decide whether or not to issue the TRO. If we issue the TRO, we set the hearing date for 2 to 3 weeks later, and it will be heard at that time, even during the suspension, because it's an emergency matter. So we already have that process in place. So there's not a need for an extension in the 19th because we're handling those matters. Is that accurate, Judge Wilson?
Yes.
Yeah.
Let's see, there's one here. Will family court be handling the moving of trials the same way as district court? Example, trials said during the break will be.
Mr. Blunt, we are not here to answer for family court. We don't know what they're doing in family court in terms of trials and all that. So we're only can answer the questions as it relates to district court on the civil and criminal side.
Thank you very much, Your Honor. There was a question off of the chat, and actually, I think that's the last one up off the chat, if I'm not mistaken.
Yes, I have one it's under miscellaneous on our list. Whether or not the court has any insight of whether the Supreme Court is considering allowing more online CLE to meet the MCLE requirements for 2020.
I don't know how the court would answer that one.
Yeah, we don't know.
Okay.
From the bar, there have been discussions, and I think those are continuing discussions, and I don't think it's a resolved issue as of yet. Is that accurate, Ann?
Yes, sir.
Judges, we are rolling up on the 2-hour mark. We have rolled through a lot of questions. There are some dribs and drabs that still appear within our list if we went back to that list, but we would be a little bit disjointed in that some of them we've not been able to determine whether the contents of some of the responses already given would be responsive to these questions. I'm going to probably, how would you like to proceed from this point forward, Judge Fields?
I mean, if you all do not have any more questions on the board, then we want to thank you all for allowing us this opportunity to let you all know what we're going to do in the 19 JDC to stand the court back up and hopefully starting give us at least to Wednesday. We're trying to make sure all our phone lines are transferred over to our homes so we can be more mobile and continue to stand the court up. I think every day we're making progress in terms of opening things back up with the court. And I'll leave it to any of my fellow colleagues who want to chime in some last words. I'll just go as I appeared on my board for about 30 seconds. Judge White?
I guess the only thing in the interim, what I will be looking into is how I can implement video court. That means where I can be in my chambers or in the courtroom, court reporter can be accessible, and the attorneys can be in their offices looking at how they're doing it, particularly in the 24th Judicial District with Judge Scott Skigel. He's already doing it. And so that's one thing that I would be looking at. Obviously, if it's a lot of witnesses, then it may be problematic. But again,
Try to keep it short, Judge White, because we're running out of time.
All right, I'm done.
All right, Judge Kelly?
I want to thank the attorneys for participating in this. I want to encourage you to tell all of your colleagues that may not be participating to look it up on the Bar Association's website to be able to get it. I hope we have not confused you more than we have. I think that special credit goes to Judge Fields. You guys have no idea what he has been doing in corralling the other judges to make sure that we can get these issues answered for you and get up and running. So I want to thank Wilson and also thank the other judges for this. May be as close as we've all worked together in years. I mean, everybody's on the same page. So thank you all. And please act professionally.
Yeah, just regarding the Parish Prison, I wanted to note that be aware that they are under really severe circumstances. They're dealing with a population. They're dealing with a threat of the crisis there. And keep that in mind when trying to contact your client. They have facilitated the court by providing rooms for the remote video, and they're working very hard in keeping distance between inmates and dealing with their own problems. So they do want to help. They've been very helpful. And if anybody out there knows of any other person that's incarcerated that can be considered for release, please bring it to our attention. The DA's office and the public defenders have been doing a very thorough job, and I think each section of court is doing the same, but there may be others out there. We do want to reduce the population as much as is reasonable. Thank you all.
Mayor Bella?
I guess my only comment would be, well, several, I guess. I can't. I do want to thank Judge Fields. Judge Fields has done a fantastic job, and I do appreciate his leadership. I do want to thank the lawyers. This is some very difficult times, and we've all talked about professionalism today, and I think that every lawyer that I've dealt with throughout this entire thing has been very professional. Not that they aren't always, but under this particular crisis, they have been. I would simply say to the defense lawyers out there who are listening to this, having been a defense lawyer for many, many years, this is an opportunity for you to get the best deals for your clients that you're going to be able to get that are reasonable. And the longer you wait, those deals may not be there. So if you've got a reasonable deal, you've got a client that ought to be done, do it. That's all I can say. And we'll try to take care of those for you.
Judge Smith?
Yeah. First, I want to thank Chief Judge for setting this up and the bar. This has been helpful. And we're going to get through this. As far as my court, quickly, if the private attorneys, if you all need anything, feel free to contact me or my law clerk, Jody Emanay. We've been able to do several bond reductions. I have a question for the criminal judges. Do we know what days Judge Higginbotham is going to be holding arraignment court? I'd like to visit if possible.
All right, we'll get that to you, Judge Smith, once we get off this line, because I know the bar is on a time frame for this Zoom.
Okay, but I just want to thank you and thank everybody, and God bless.
Judge Anderson.
Well, I'd just like to thank Judge Fields and the bar for giving us this opportunity to get information now. It's trying times. Nobody's ever seen this, and we're trying to work through it as y'all are. And if you have any other suggestions, contact the judges. If you have any questions, contact the section judge dealing with the case. But thank y'all for the opportunity.
Judge Jackson.
Again, I'd like to thank Judge Fields also, but I would like to suggest that when you're making requests of our judicial assistants or our law clerks, that you have all of the important information that you need to have. They don't have time to look up a lot of information for a lot of people. You need to do a lot of the legwork before you make your request. Contact the DA assigned to your case. Figure out why your client is actually in jail. I just got off the phone with her. We went through people that we had requests for. And, some people have a $200,000 bond in another section of court. Well, my lifting a probation hold isn't going to do a whole lot unless you have already talked to that other judge and you've made arrangements for a bond reduction. So I would just ask that you please do your legwork before you make your request to our assistants so that we can handle your request as expeditiously.
Judge Morvant.
Be patient and professional as we work our way through this.
Well, thank you, Mr. President and Madam Presidents, for giving us this forum. We really appreciate it, and just continue to contact our offices. We're going to do the best we can as we work together. That's the judges and the bars to get through this public health crisis. So thank you all.
Judge, one last thing, if I may. I know we were going to remind everyone that this is as it is currently, and this is a very fluid situation. So for anyone that may tune into this, things may change, but they can rely upon the information as of this date.
Right.
I'm just want to say thank you to the court. I think we have obviously a situation we've never seen before in our lifetimes, but this is also proof positive that we have not only a unique bar, but a unique court, and willing to open itself up and willing to do all that is possible. Thank you, Judge Fields, for your leadership of the court. This has been I think I'm just watching the chat and all of the thank yous that are flowing in. People are really appreciative, and not only for the lawyers, but for the folks that we serve, our clients are pleased with the work that y'all are showing as true public servants. Thank you, guys.
Thank you all.
Thank you. That's it, good folks. Take care.
Thank you.
Stay prayerful and wash your hands.
Thank you, judges.
Be safe, everyone.
Thank you.
Take care of
Okay.
yourself.